was intentional because the minimum filing fee is $750. So why would anyone file an arbitration for a $150 watch when the minimum fee is $750? It can also be demonstrated by AT&T, which is a U.S. mobile phone company with over 120 million subscribers, who requires all of their all their customers to agree to an arbitration clause. And out of those 120 million customers, over the last 5 years, they've averaged 27 arbitrations a year. So it's clear, and it's clear to Congress and to the representatives in the United States that in certain cases, arbitration is being used by corporations to prevent claims from their customers. The second reason that the Federal Arbitration Act is currently under scrutiny is because the arbitration institutions in the United States have failed to act to this abuse. And then the third reason is that the courts have largely failed to act. There have been a few state cases where courts have overturned arbitration agreements of this sort, but on the federal level, there's been 2 U.S. Supreme Court cases that have upheld these sorts of arbitration agreements. Now Congress is close to acting, and with polls showing that 84% of Americans across both parties support this new act, which is the one thing that Democrats and Republicans seem willing to agree to right now, it looks likely that the Federal Arbitration Act will soon be trimmed by the Forced Arbitration and Justice Act. So, with that background in mind, I'll start by introducing our first speaker, which is Mr. Bernardo Cremetis. Mr. Cremetis is a founding partner of Cremetis and Associados law firm in Madrid. He's a pioneer in the field of international arbitration, whose experience centers on international commercial arbitration and investment disputes. He has participated in some of Spain's most important M&A transactions. He also acts as an arbitrator in domestic and international disputes, including both commercial arbitration and investment protection. Mr. Sermatis is a member of many professional and international arbitration institutions and is a frequent speaker at international arbitration conferences around the world. He is also an author of numerous publications, and he will speak to us today about the role of third-party funding and increasing access to international arbitration.
Good morning, ladies and gentlemen. First of all, I would like to congratulate the organizers of this very successful conference. It's really an honor to be with you today in Riyadh. I've been asked to speak about the role of third-party funding in increasing access to international arbitration. Everybody knows what Jeremy Bentham said: wealth has indeed the monopoly of justice against poverty. Sometimes we complain that arbitration is very costly. We see that our international arbitration especially has a lot of costs, and the problem of access to international arbitration justice is something to take into consideration. We know that lawyers, experts, translators, transcribers, hotels, fees of the administrating institutions sometimes go into millions. And that's the reason why there was necessity of considering the problems to access to justice. Especially arbitration proceedings could be very long years. Bifurcation, annulment after we get the arbitration award, execution of the award. So sometimes the bill the claimant or the respondent has to pay. And that was the reason why this third-party funding started to be important in the life of international arbitration. Nowadays, I think many claimants go to this industry of finance in order to get access to international arbitration. What is the importance of this third-party funding? Third-party funding is based on risk assessment, risk sharing in international arbitration. Contingency fee was, within lawyers, part of the remuneration. But now contingency goes into this finance. Now is not only a banking finance in order to promote these arbitrations. The third-party funding is finance without recourse. It's nowadays considered more an investment than a loan. Finance without recourse means that the financer is ready to finance the cost of this arbitration without recovering the loan. There is no loan, there is an investment. What is the consequence of that? The consequence of that is that the funder is paying the cost and he doesn't recover anything if the case is lost, but the funder has an agreement with the party so that only if the arbitration is won, then the funder will recover what the funder invested in that arbitration, and there is an agreement about sharing the recovery of what the damages has been assessed by the arbitration tribunal. So nowadays, this third-party funding has given the opportunity to establish funds. And you see that these funds, somehow, they are becoming big funds. Even we see that sovereign funds are investing in this arbitration funding. What is the basis of this third-party funding? Of course, is the agreement between the funder and the party who seeks this finance. And as you can imagine, it's a very important part of the industry is to assess the risk they take. And that's the reason why it's very important for the funder to make a very detailed due diligence, analyzing all the factors such as the value of the lawsuits, the amount to be advanced, and that's something very important that the lawyers normally getting in touch with these funds, they should assess what is the cost they foresee, not only for their fees, but for everybody intervening in the arbitration proceedings. The due diligence has to take into account jurisdictional obstacles. It's very important for the fund to see what are the obstacles that the claim might have. The defenses, they have to realize what are the possible defenses that the respondent may take. Nature and length of the proceeding, including venue and applicable rules. Sometimes the funder wants to know what are the consequences of making the choice of a venue. Venue in Riyadh, venue in Madrid, venue in London, venue in New York. That's something they have to assess because it takes consequences in the cost. Possibilities of a settlement. That's another thing they have to take into consideration in this due diligence, because the settlement, it's a very important part of the recovery. Sometimes the funds wants to have settlement as soon as possible. Why? Because their agreement is put into place and they have the money coming back. Credit worthiness of client and the opposing party, especially taking into consideration the collection prospects. If the respondent is insolvent, I don't think a funder will put the money, because at the end of the day, even if they have a very nice arbitration award, the award cannot be executed. Counsel chosen and compensation structure. I think that's a very, very psychologically very important part of the decision of the fund. Normally, the fund is connected with the lawyers who are representing the clients, the claimant or the respondent, because the funding could go both ways. And sometimes the funder has very close ties to those law firms because they rely on the expertise of the law firm in compensation. Compensation structure. Normally, what the fund wants from the lawyer involved is that he shares the risk. And that's the reason why normally the funder will request that the lawyers somehow they are compensated in a contingency fee, totally or partially, because what they want is that the lawyer who is representing the client to be funded should take the risk in order to go ahead. Additional obligation of the party to be funded linked to the potential risk of recovery, such as previous funding agreements or other alliance. How is the fund compensated? As I told you, the fund is not going to be compensated if the case is lost, only if the award is positive. Then there are two ways to be compensated. Cost return of the investment. And normally the practice is that the fund is going to request 3 times the investment in the arbitration proceedings. And apart from cost return, normally is in the agreement a percentage of the recovery. That's the reason why the funders avoid the using of the word loan. Claims is a financial asset, what normally for the lawyers, for the traditional lawyers, is difficult to understand, but a claim is a financial asset. And that's the reason why it's very important that in this arbitration agreement, the funder has to establish what are going to be the relationships between the fund and the client, the fund and the lawyer. The lawyer is the one who has the client to take instructions from. But if the fund is investing money in that case, you will understand that the fund should be entitled somehow to participate in the decisions taken by the lawyer. And that's a point important to take into consideration due to possible conflicts of deontology. The lawyer has a client. The client is the one who instructed him and not the fund. But anyhow, the fund has somehow to take part in those decisions. In this arbitration, in this agreement with the fund, you have to establish how everybody is going to be paid, how the installments, how the lawyers will receive the money, and how the experts and how everybody who is involved in the costs creating in the arbitration should be paid. And a very important part of this agreement is the cancellation agreement, in the cancellation clause of the funding agreement. Sometimes in the arbitration, in the funding agreement, you will find a very detailed agreement, a very detailed clause about cancellation and the consequences and the reasons for the cancellation of the funding situation. What is the relationship between third-party funding and the proceedings? It is very important, transparency. Sometimes people try to avoid the presence of a third-party funder in the arbitration proceedings. That's, I think, a mistake. Transparency is very important. And sometimes, if you don't disclose the existence of this third-party funding, you might come into problems of conflict of interest. Let's put the question that the fund is working with different law firms. If you don't make a transparent disclosure of the third-party funding, it could very well happen that the fund is working with partners of the arbitrators. It could very well happen that the fund is involved in collateral arbitration proceedings. It is very important, transparency, and I think it's a big mistake not to disclose the existence of this funding. Who is entitled to the control of the proceedings? Sometimes people say if the fund is paying, the fund might be entitled to control the proceedings. And I come back to what I said previously. There are deontological problems for the lawyers because the lawyers have a client, and the client is the one who has to give instructions to the lawyers. If the funder intervenes in the control of the arbitration proceedings, let's think about, for instance, settlement negotiations, then there could be some deontological problems for the lawyers involved in that proceedings. What are the limits of discovery, for instance? Do the relations between the lawyers and the funder are submitted to the privilege? I don't think so in many cases. But anyhow, it is important to take into consideration that discovery might request the relationship between the funder and the client, the funder and the lawyers. Sometimes discovery goes into a very difficult situation. Let's suppose that the other party, who is not funded, discovers that the party went once or twice or three times to different funders in order to get funding, and they were rejected. How is it possible in discovery to request the correspondence and the relationship between the party and the funder who refused? Because it's very important to know why they refused. And that's something very interesting in matter of limits of discovery. Cost allocation. Sometimes the arbitrators, when fixing the cost of the arbitration, probably should take into consideration the presence of the funder. And is the other party, the losing party, paying those costs of the funding? That's something to really discuss case by case. I think the presence of the third-party funding in investor-state arbitration, it is putting some difficulties in practice. Let's suppose that a party from Spain is funded in a case against Mexico. If the funder is the one coming from a third country, is the relationship really covered by the Spanish-Mexico bilateral investment treaty? The fact that a third-party funder intervenes in the financing of that arbitration interstate on a BIT basis is really creating jurisdictional problems about intuitu personae, who is really covered or not by that arbitration, by that bilateral investment treaty. I think it's important because sometimes arbitrators like to know who is the real party in an arbitration. In arbitration, sometimes appear formally someone, but in fact, there is a funder who is behind the screen of that arbitration. And I come to my final observation. We are used to see third-party funding just financing the cost of the arbitration. But nowadays, there is a secondary market in third-party funding. And that's the reason why we see that people start the arbitration, the funder asks some of the colleagues to participate in a syndicated financing agreement to finance the party, and that's the reason why it is nowadays very important to monetize the claim. I told you that nowadays the claim is a financial asset, and that's the reason why it's very important for the funders to monetize the claim so that they can share and put in the market to get some people to collaborate in the financing. Nowadays, it's very important the market in which the awards are being sold. And who is at the end the one who is entitled to enforce that award? The one who won or the one who has purchased? It is quite often the case that the company who is claiming against the respondent sometimes is sold and just the bank has purchased, for instance, the shares of the claimants. Who is, if the claimant continues to be formally that company, who is the formal and the real party in this arbitration? As you can imagine, this secondary market, who is now very important in international arbitration, is getting more and more interesting, and especially taking into consideration the investor-state arbitration that creates a lot of problems nowadays. But anyhow, the third-party funding has come, recently has come to the international arena and is going to stay. Now is the reaction of all the people involved in international arbitration. It's the moment to react and to take positions, because nowadays we see that these third-party funders are very active in the international arbitration, both commercial and investment arbitration. And at the end, the critics, now that it's normal to see lots of critics, especially in investment arbitration, might take an increased role because some people critique the idea of third-party funding because they believe that through this third-party funding, the lawyers will increase their interest in promoting arbitrations, and sometimes they believe that the speculation is present in the third-party funding. That's not true in any case, but anyhow, the critics are there, and I think international arbitration has to face that kind of critics who started some years ago, especially in the investment arbitration, but now I think commercial arbitration is as well under this point of view of the critics. Thank you very much and enjoy your conference.
Thank you very much. Our second speaker is Dr. Abdulaziz Al-Sulaim. Dr. Al-Sulaim has a PhD in arbitration and foreign investments. He has participated as a speaker in various conferences in Saudi Arabia and internationally. Dr. Sulaim has published several articles and books related to arbitration in the kingdom and the role of judiciary in the kingdom. He will speak to us on the role of the judiciary in making Saudi Arabia a safe seat for arbitration. Thank you.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين. صلى الله وسلم وبارك على نبينا محمد وعلى آله وصحبه أجمعين. بداية نتقدم بالشكر والتقدير والامتنان للمركز السعودي للتحكيم التجاري، سعادة رئيس مجلس الإدارة وأعضاء المجلس وسعادة المدير التنفيذي للمركز وجميع الإخوة في المركز والرعاة والمشاركين على تنظيم هذا المؤتمر الدولي الكبير والمهم، وكذلك الشكر لأعضاء هذه الجلسة وسعادة مدير الجلسة. ويشرفني أن أكون بينهم اليوم نيابة عن فضيلة الشيخ الدكتور عبد العزيز الناصر القاضي في محكمة الاستئناف منطقة الرياض، والذي يبلغكم جميعا التحية والتقدير. بداية، لا يخفى أن التحكيم اليوم أصبح على الصعيد الوطني هو القضاء الخاص والطريق الذي يختصر على المحتكمين في غالب تطبيقاته اليوم الجهد والوقت والتكاليف. أما في مجال التجارة الدولية وعقودها فقد أصبح هو القضاء الأصلي والطريق الأساسي للفصل في الخصومات الناشئة عنها، لأن القضاء الوطني كما هو معروف في أي دولة لا يستطيل في اختصاصاته إلى خارج حدود ولايته المكانية إلا في نطاقات مخصوصة ومسارات معينة في إطار التعاون القضائي في المجال الموضوعي والإجرائي كالإنابات القضائية وما في حكمها. ومن هذه النقطة بالذات يتبين مدى الأهمية البالغة للتحكيم بوصفه أحد أهم الضمانات الإجرائية للاستثمار الأجنبي في جميع الدول. والمملكة العربية السعودية إذا استعرضنا تاريخها التشريعي في مجال التحكيم نجد أنها استعملت التحكيم وأقرته في تشريعاتها وعقودها منذ وقت مبكر، وبالتحديد منذ 100 سنة هجرية. ففي عام 1341 للهجرة الموافق لعام 1923 وقعت المملكة اتفاقية امتياز للتنقيب عن النفط، وتضمنت هذه الاتفاقية شرطاً تحكيمياً، وكان الذي وقع الاتفاقية عن الجانب السعودي هو جلالة الملك عبد العزيز رحمه الله تعالى. ومن المعلوم أن مبدأ سمو الاتفاقيات الدولية يجعل هذه الاتفاقية وأمثالها جزءاً من التشريع الوطني للدولة تلتزم أجهزتها القضائية والإدارية بتنفيذها والعمل بموجبها. وفي مسيرة تشريعية حافلة وفي خلال 100 سنة انضمت حكومة المملكة وأبرمت أكثر من 200 اتفاقية ومعاهدة متعلقة بالتحكيم أو أحالت إليه أو نصت على بعض الإجراءات المتعلقة به، سواء كانت هذه الاتفاقيات اتفاقيات ثنائية أو معاهدات إقليمية أو دولية. كما أصدرت خلال هذه المسيرة الحافلة أكثر من 70 أداة نظامية متعلقة بتطوير التحكيم وتجويد إجراءاته، أو أكدت على حكم إجرائي من أحكامه، سواء كانت هذه الأداة نظاماً أو لائحة أو تنظيماً أو قراراً. واهتماماً من المملكة بالتحكيم، فقد كانت هي أول دولة عربية أصدرت نظاماً مستقلاً وعصرياً للتحكيم، كان ذلك في عام 1983. ثم توجت هذه المسيرة التشريعية الحافلة بصدور نظام التحكيم الجديد، والذي جاء وفقاً للنظريات التشريعية الحديثة في مجال التحكيم على المستوى الدولي، وجاء كذلك موافقاً لأحكام ونصوص قانون الأنسترال النموذجي للتحكيم التجاري الدولي وتعديلاته لعام 2006، يضمن بذلك إجراءات تحكيمية مشابهة للإجراءات التحكيمية النظيرة على الصعيد الدولي. ثم تبع ذلك صدور قرار مجلس الوزراء الموقر بإنشاء المركز السعودي للتحكيم التجاري عام 1435-2014، ويعتبر هذا القرار بداية للتحكيم المؤسسي المتخصص المستقل في المملكة. ومن خلال نظر المتابعين وبشهادة المتخصصين من خارج المركز، نلاحظ أن المركز قد وصل في خلال أول 5 سنوات من إنشائه إلى مراحل وإنجازات لم تبلغها مراكز تحكيم دولية في أول 20 سنة أو أكثر من إنشائها. ومن أهم ما يعزز اللجوء إلى التحكيم الدولي في المملكة الأحكام الموضوعية والإجرائية التي تقتضيها وتوجبها اتفاقيات الحماية والتشجيع المتبادل للاستثمارات التي أبرمتها المملكة مع عدد من الدول، حيث أبرمت المملكة أكثر من 23 اتفاقية ثنائية في مجال التشريع والحماية المتبادلة للاستثمارات. وجميع نصوص هذه الاتفاقيات كما هو معروف منقولة بنصوصها من الصيغ النموذجية الدولية المعتمدة في هذا المجال ومتوافقة معها، بما فيها النصوص المتعلقة بالتحكيم وإجراءاته، حيث نصت هذه الاتفاقيات في نصوص مطولة على أحكام وإجراءات متعلقة بالتحكيم، بما يضمن الحماية والتشجيع للاستثمارات، وبما يضمن لها البيئة الاستثمارية والإجرائية والقانونية المناسبة، وبما يضمن كذلك تشابه العملية الإجرائية للتحكيم في المملكة بالإجراءات النظيرة على الصعيد الدولي، حيث إن هذه الاتفاقيات كما هو معروف هي من ضمن آلاف الاتفاقيات الثنائية التي تعقد بين الدول وأشخاص القانون الدولي، حيث بلغ عدد هذه الاتفاقيات الثنائية بين دول العالم المتعلقة بالاستثمارات المتبادلة خلال 10 سنوات في الفترة من عام 1999 حتى عام 2009 2700 اتفاقية ثنائية. وجاء التأكيد على بعض الأحكام الواردة في هذه الاتفاقيات، ومن ضمنها الأحكام المتعلقة بالتحكيم في مشروع نظام الاستثمار الذي قامت الهيئة العامة للاستثمار مشكورة بإتاحة فرصة الاطلاع عليه للعموم في موقعها الإلكتروني واستقبال مرئيات العموم المختصين بشأنه. وهذا النظام في حال صدوره أيضاً سيعزز الأحكام المتعلقة بالاستثمارات وتشجيعها وحمايتها وأدوار التحكيم في العقود والتجارة الدولية. فإذا كانت هذه النصوص المتعلقة بالتحكيم في هذه الاتفاقيات الثنائية في مجال الاستثمار منقولة بنصوصها عن الصيغ النموذجية الدولية، فإن ذلك يضمن تشابه الممارسات الإجرائية والموضوعية في مجال التحكيم، ويعزز ذلك ويؤكده أن نظام التحكيم الحالي هو متوافق مع قانون الأنسترال النموذجي للتحكيم التجاري الدولي، وكذلك انضمام المملكة عام 1980 إلى اتفاقية البنك الدولي بشأن تسوية منازعات الاستثمار بين الدول ومواطني الدول الأخرى، وانضمامها أيضاً عام 1984 إلى اتفاقية تشجيع وحماية وضمان الاستثمارات بين الدول الأعضاء في منظمة التعاون الإسلامي، وانضمامها أيضاً عام 1993 إلى اتفاقية الاعتراف بقرارات التحكيم الأجنبية وإنفاذها، وكذلك انضمامها إلى عشرات الاتفاقيات والمعاهدات التي نصت على التحكيم وتفعيله والإحالة إليه والإلزام به في مجالات متعددة، منها على سبيل المثال وعلى سبيل الإجمال التعاون القضائي والنقل الدولي للبضائع والنقل الجوي والخدمات الجوية والنقل البحري والتجارة البحرية وسلامتها، وفي الأعمال المصرفية والصناعية وصناعة الاتصالات، وفي حماية الملكية الفكرية وحماية المستهلك والربط الكهربائي والتجارة الدولية والتجارة الإلكترونية، وفي مجال الزراعة والإحياء البيئي، وفي مجال الطاقة والاستخدامات السلمية للطاقة النووية والمتجددة والهندسة الوراثية والحيوية، وفي المسائل المتعلقة بالبنى الأساسية، وفي المجال التراثي، وفي أعمال البريد الدولي وغير ذلك من المجالات المتعددة التي التزمت المملكة بموجبها بإعمال التحكيم وتفعيل موجبه وتهيئة البيئة التشريعية والإجرائية والقضائية والإدارية لضمان حماية الاستثمار وتشجيع المستثمرين. وجميع هذه الأحكام والاتفاقيات والمعاهدات التي انضمت إليها المملكة جاءت لتحقيق ما استهدفته حكومة المملكة من تحقيق التنمية المستدامة وتعزيز التحكيم الدولي وتهيئة الفرص لرؤوس الأموال الأجنبية للمشاركة في التنمية الاقتصادية، واستغلال الفرص لرؤوس الأموال الأجنبية للمشاركة في التنمية الاقتصادية، واستغلال الفرص التي تزخر بها المملكة من خلال تشجيع الاستثمارات الأجنبية واستقطابها وحمايتها بما يحقق العائد التنموي على الاقتصاد الوطني. وهذا كله هو ما نصت عليه رؤية المملكة وبرامجها التي جاءت بتفعيل الحماية والتشجيع المتبادل للاستثمارات الأجنبية مع الدول الأخرى، وتهيئة الظروف المناسبة لنموها وازدهارها لتسهم في تحقيق الأهداف المرجوة منها. فقد نصت الرؤية في مواضع كثيرة منها على الاهتمام بالجوانب الاستثمارية والاقتصادية، فنصت على سبيل المثال على تسهيل سبل الاستثمار والدخول في شراكات طويلة الأمد من أجل التبادل التجاري، وعلى فتح أبواب الاستثمار من أجل تشجيع الابتكار والمنافسة وإزالة كل العوائق التي تحد من قيامه بدور أكبر في التنمية، كما نصت على تشجيع الاستثمار المحلي والأجنبي في قطاعات الصحة والخدمات البلدية والإسكان والتمويل والطاقة وغيرها، وتسهيل تدفق استثمارات القطاع الخاص، وتهيئة بيئة مشجعة للاستثمار على المدى الطويل، وإيجاد بيئة جاذبة للمستثمرين المحليين والدوليين على حد سواء، وتخفيف القيود المتعلقة بالملكية والاستثمار الأجنبي، إلى آخر نصوص الرؤية وبرامجها التي جاءت بتفعيل الحماية والتشجيع المتبادل للاستثمارات الأجنبية بين الدول. وجميع هذه النصوص التشريعية في الأنظمة والمعاهدات والاتفاقيات التي عززت من أدوار التحكيم قد انعكست نتائجها على العمل القضائي والإجراءات التحكيمية بشكل مباشر، فإن مؤسسات التحكيم الدولي مهما استقلت بالإجراءات التحكيمية فإنها لا تستغني عن القضاء الوطني، خاصة في مرحلة تنفيذ الحكم التحكيمي. ومئات الأحكام القضائية التي تنشرها وزارة العدل من خلال مطبوعاتها ومن خلال الموقع الإلكتروني هي خير دليل على أن هذه الأحكام القضائية قد جاءت كتطبيقات مباشرة ومفسرة وموافقة للنصوص التشريعية المشار إليها في الأنظمة والاتفاقيات وفي حدود اختصاصها المحدد لها نظاماً وقضاءً. كما أن وزارة العدل تنظر إلى التحكيم والوسائل الأخرى لحل النزاعات كالوساطة والتوفيق على أنها الوسائل الملائمة للفصل في المنازعات، وليست وسائل بديلة، إيماناً من الوزارة بأهمية صناعة التحكيم والتحكيم المؤسسي خاصة. وبموجب نظام التحكيم فإن الجهات القضائية ومحكمة الاستئناف المختصة على وجه الخصوص تقوم بجميع الأدوار المنوطة بها الداعمة للتحكيم والمساندة له، بما يحقق الأهداف المرجوة منه في تعزيز الاستقلال التحكيمي والمرونة الإجرائية لأطراف الخصومة التحكيمية. والشكر والتقدير في ختام هذه الورقة للمركز وللجميع ولسعادة مدير الجلسة.
Thank you very much. Our third speaker today is Mr. Martin Valasek. He's a partner with Norton Rose Fulbright, Canada. Sorry, hold on, I'm taking off this because the dual translation is affecting me. Martin is a leading practitioner in the area of international arbitration with extensive experience in both investor, state, and commercial contract disputes. He regularly acts as counsel and also sits as an arbitrator. His experience covers a wide range of legal systems and industries, including aerospace, banking, construction, mining, energy, manufacturing, retailing, and franchising. He's provided winning guidance to clients in both transactions and unicameral rules and other, he's provided winning guidance to clients in both transactions and disputes under all the leading rules, including the ICC, the LCIA, the ICSID, and the unicameral, and other institutional and ad hoc regimes. He has acted as arbitrator and tribunal secretary in several other important arbitrations, including the multi-billion-dollar Yukos Energy Charter Treaty arbitration. And he will speak to us today on the topic of class and collective arbitration.
Thank you very much, Tim. I'd like to express my own thanks to the Saudi Center for inviting me to this conference. It is indeed an honor and a privilege to be part of such an ambitious initiative to make the Center a leading institution for international arbitration in this region. So I thank you. Question I have been asked to address today is whether class or collective arbitration is a way of increasing access to international arbitration. Short answer is yes. But the longer answer I will develop in the next 15 minutes will show that in practice, it can be quite complicated. I will address the topic in 4 parts. First, I'll give a very brief review of collective or class remedies, especially since this is a new area for this country, as I understand it. Next, I will discuss whether the economic rationale for a class remedy can be reconciled within the legal framework of international arbitration. Third, I will spend a few minutes describing the experience in the United States, where this issue has been debated for decades and where the principles have been highly developed. And finally, if there is time, I will look with you at some of the institutional rules that have been developed for class arbitration Yesterday, Mr. Landau, Toby Landau, invited the Saudi Center not just to replicate, but to innovate. So the Saudi Center might look at some of these rules as inspiration to develop rules in this area. So let me first address the notion of a collective remedy. There are two main types of collective proceedings. Representative proceedings, generally known as class actions, and aggregate proceedings. I will address each in turn. Some jurisdictions address collective injuries by creating mechanisms allowing claims to be brought by a representative on behalf of a class of claimants or plaintiffs. The prototype here is the class action that is available under both state and federal court rules in the US, as well as some other jurisdictions like my own country of Canada. A traditional lawsuit typically involves all claimants and defendants in the case being present and involved in the proceedings. By contrast, a class action involves at least one of the parties, typically the claimant, representing a group of people who are similarly situated but absent from the proceedings. The representative seeks to obtain relief for the entire class it is representing for a civil wrong that the defendant purportedly committed. Class actions are most common where claimants allege that a large number of people have been injured by the same defendant in the same way. In many cases, the isolated injury to each class member would not justify the expense and burden of separate claims and lawsuits by each claimant. So instead of each class member filing his or her own separate lawsuit, the class action allows a court to resolve in a single proceeding the claims of all class members, while allowing individual class members to opt out of the class. Class actions are generally available for any claims that a claimant might allege, as long as the legal and procedural requirements for bringing a class action are met. Certain claims are better suited for class treatment than others. The industries that most commonly encounter class actions are consumer-facing industries, such as the retail industry, automotive, insurance, pharmaceutical, and financial services industries. The other type of collective action is an aggregate proceeding, such as, for example, the group litigation order in the English court system. The group litigation order results in the creation of a judicial registry of individual claims that arise out of the same fact pattern and then are assigned to the same judge for management purposes. As compared to a class action, this is generally an opt-in procedure. I understand that the Saudi judiciary has not adopted the class action method of litigation. Thus, where a group of claimants have identical claims against the same defendant, they must file several and separate cases. Practically, a lawyer can coordinate the filing of all related cases at the same time and have them referred to one panel. However, this is not considered a class action or treated as such. But there is an exception. I understand that regulations were very recently adopted in Saudi Arabia, allowing class actions for civil violations of laws relating to the regulation of the capital markets. This is therefore a mechanism that may quickly gain traction in this country, at least in the courts. But the question we are interested in today is whether this notion of a class remedy can be reconciled with the framework of international arbitration. I turn to this now. Broadly speaking, the economic rationale for class or collective litigation applies equally to arbitration. One can imagine a party bound by an arbitration clause that would benefit from class or collective arbitration, namely a party that has a claim of lesser value that does not justify the cost and burden of commencing an individual arbitration, but who could advance its claim by joining forces with other parties who have similar or identical claims, which could be grouped together and decided in a single arbitration. There is an obvious cost and efficiency rationale for such an approach. Where the issue in dispute is substantially the same for every claimant in the group, the substantial cost of an arbitration could be split among all of the claimants instead of each claimant having to commence and pay for its own arbitration. In his introduction, Tim mentioned a few concrete examples. For example, the purchaser of a $150 watch that would need to pay a $750 filing fee in order to advance a claim in arbitration. One can see immediately that in such a situation, access to justice is denied for the individual claimant unless a class remedy is available. One solution is the one that Tim mentioned in his introduction, which is currently apparently being considered in the US Congress, which is legislation or legislative amendments that would invalidate arbitration clauses in such a context, allowing the plaintiff who is otherwise bound by the arbitration clause to proceed to the courts with access to a class remedy in the courts. Another solution, which is the one that I'm interested in for purposes of this presentation, is whether a class remedy might be available in arbitration, thereby giving effect to the arbitration clause, but also giving effect to the economic rationale of a collective remedy. The problem is that the economic rationale often comes in conflict with the legal framework for arbitration. And why is that? Well, arbitration is based on the foundational notion of consent, the parties' agreement to arbitrate. Everything depends on what the parties have agreed in their arbitration clause. The issue of a class remedy in arbitration is therefore straightforward, where the parties have expressly consented to class or collective arbitration. In that case, there can be no objection by the defendant to a claimant bringing such a proceeding. After all, the parties have agreed to it. But frankly, such express consent is rare. To the contrary, industries will often insert individual arbitration clauses precisely to avoid a class remedy in the courts. In these circumstances, there is a clear tension between the framework governing arbitration and the rationale in favor of class proceedings. Under the legal framework for arbitration, strictly speaking, the only parties who can take part in a single arbitration are the parties who are bound by one and the same arbitration clause under one and the same contract. So how is this tension resolved? Well, it's interesting to look at the experience of the United States, which has grappled with this for, as I said at the beginning, several decades. Historically, up to the 1980s, the courts in the US have upheld the strict approach to the interpretation of arbitration clauses and rejected attempts by claimants to bring collective or class arbitrations. typical quote from a court, this is from 1975, read, "A class action cannot be used to subvert an otherwise enforceable agreement to arbitrate contained in a valid contract merely because other individuals who might qualify as members of a class were subject to the same provision." A breakthrough came in the early 1980s in California, which is a jurisdiction which is known for its pro-class action philosophy. In that case, franchisees of a grocery chain argued that their claims against the franchisor should fall outside the scope of the arbitration clause that was contained in all of their contracts, or alternatively, that the claim should proceed as a class action in arbitration. The courts found that the franchisees could not escape the arbitration clause, but the Supreme Court of California ordered an arbitration on a class basis. It reasoned as follows: an adhesion contract is not a normal arbitration setting. If the alternatives in a case of this sort is to force hundreds of individual franchisees each to litigate its cause in a separate arbitral forum, then the prospect of class-wide arbitration, for all its difficulties, may offer a better, more efficient, and fairer solution. Where that is so, and gross unfairness would result from the denial of opportunity to proceed on a class-wide basis, then an order structuring arbitration on that basis would be justified. Outside California, though, courts still generally did not allow class arbitration unless the clause provided expressly for it. This changed in 2003 when the US Supreme Court issued its decision in a case called Green Tree Financial versus Basel. In Basel, the Supreme Court held that class arbitrations are not inconsistent with the US Federal Arbitration Act, and that the availability of class arbitration depends on the terms of the parties' arbitration agreement. Crucially, the court decided that whether an arbitration agreement authorizes class arbitration is an issue to be decided by the arbitrator. This led to a very substantial increase in class arbitrations in the US, and two arbitral institutions in the US, the American Arbitration Association and an institution called JAMS, standing for Judicial Arbitration and Mediation Services, adopted institutional rules designed specifically for class arbitrations. This trend was reversed, essentially, and recently quite significantly reversed by the US Supreme Court, which has suggested in a number of quite complicated decisions to interpret that the issue of whether an arbitration clause allows class arbitrations should perhaps be decided by the courts, and they have issued decisions which have restricted the ability of courts and arbitrators to find that an arbitration clause provides for class arbitration. So we see that it really is a challenge in this environment to get a case to class arbitration. I have about a minute left. I thought I would just look briefly at what a class arbitration looks like if it in fact proceeds before an arbitrator. And I do that based on the rules that have been adopted by, as I said, the two American arbitral institutions. Essentially, under both sets of rules, the arbitrator is asked to make three decisions. First decision is a determination whether the arbitration agreement permits the arbitration to proceed as a class. That's what we've just been discussing. This is easy where the arbitration agreement is explicit. Where the arbitration agreement is ambiguous or silent, it becomes much more complicated, as we've seen. Assuming that the arbitrator decides that the action can proceed as a class arbitration, the second decision is a determination whether the proposed group of claimants can in fact be certified as a class. And both rules essentially adopt the criteria that exist in the state and federal court rules for making that determination. And finally, assuming the class is certified, the final decision is a decision on the merits, which is a reasoned decision that defines the class. Based on my research, in fact, very few US class arbitrations actually result in a final award on the merits. And the vast majority of cases are in fact settled, withdrawn, or dismissed. Now, opponents of class arbitration say that this statistic shows that class arbitrations frustrate the efficiency that arbitration procedures are meant to offer. But proponents point out that class treatment enhances communication and negotiation between the two sides of the dispute, ultimately leading to high settlement rates. So thank you for your attention, and I'll look forward to any questions you might have.
Thank you, Martin. Our next speaker is Colonel Anthony Abrams. Colonel Abrams is the Director General of the Chartered Institute of Arbitrators. He's qualified as a lawyer and specializes in civil litigation. Colonel Abrams has considerable hands-on experience in legal practice management, which he has reinforced academically by gaining an MBA with distinction from Nottingham Law School. Colonel Abrams also sits as a deputy district judge. In 2006, Colonel Abrams was mobilized with the British Territorial Army to undertake an operational tour in Iraq. While there, he worked to improve and develop a passion for the rule of law, and he also dealt with human rights issues. For his work in Iraq, Colonel Abrams was awarded the Bronze Star by the United States, and he will speak to us about the role of arbitration institutions in conducting cost-efficient arbitral processes.
Thank you, Tim. Good afternoon, Your Excellencies, ladies and gentlemen. And let me start by saying how pleased, delighted, and indeed honored I am to be here today at the invitation of the SCCA. I would like to thank the board and the executive of the SCCA for putting on this magnificent conference, and all of the help and assistance that they have given the speakers in getting here, the administration behind it, which has been incredibly smooth. Chartered Institute of Arbitrators, CIARB, has had the pleasure, and I mean pleasure, of working with the SCCA team over the past 2 years in developing a program for the delivery of our training in the Kingdom of Saudi Arabia, and that program will be delivered in Arabic. Thank you to the SCCA. Chartered Institute of Arbitrators is not the same as perhaps a normal arbitral institution. We do not administer arbitrations. That is a deliberate policy on our part because we believe that it puts us in a position where we can work with all the arbitral institutions for the greater good of the rule of law and putting arbitration at the forefront of dispute resolution. So what are we? We were an institution founded in 1915. We have grown since then from a small English professional institution In 1979, we received a charter from Her Majesty Queen Elizabeth II, and that charter gives us an objective, and that objective is to promote and facilitate arbitration and all forms of alternate dispute resolution globally. In fulfilling that mandate, we now have 16,500 plus members in 134 countries, and something like 69% of the membership is now outside the United Kingdom. Here in the Kingdom of Saudi Arabia, we have some 80 members, and that is growing thanks in a large part to the efforts of the SCCA and the cooperation that we have with them. What I'm asked to talk today is about the role of the institutions within arbitration and making that cost effective. We fulfill our role as an institute in what we call our golden thread. That comes in three elements. Firstly, we educate, we train, and we qualify neutrals in arbitration, mediation, and, where relevant, adjudication. Secondly, we, what we call it, develop the learned society. And thirdly, we facilitate all forms of ADR. Looking at the first element, that is the education, training, and qualification, I'm going to deal firstly with qualification itself. We in CIR are the only organization that has a globally recognized qualification as arbitrator. So as an institution, how do we assist arbitration? By, obviously, training the neutral so that as one becomes a fellow, and it matters not where you train, whether in Saudi Arabia, South Africa, or Seattle, or Singapore, by taking a qualification, by taking the exam, by gaining the experience that entitles you to be called a Fellow of the Chartered Institute of Arbitrators. Firstly, the end user, the mercantile and the commercial community know that there is an individual that has achieved a standard, a high standard, a golden standard in qualification. And of course, the arbitral institutions, in appointing a neutral, can be satisfied that that individual has the knowledge and the efficiency, the knowledge that he can actually or she can deal with an arbitration in a proper manner so that it becomes an efficient, fair, and indeed a respected process. Just coming back again to the initiative we have with the SCCA, we are starting the process of training in Saudi Arabia so that within this kingdom there will be a body of individuals that ultimately will become fellows and therefore competent to stand and sit as arbitrators in the future. The program starts this month when we have 147 delegates who are entering the training program. But it's not just training the neutral that will enhance arbitration here in the kingdom and also globally. We also need to train, and we as an institute do train, judiciary. The role of the judiciary in arbitration is very specific when one looks at the UNCITRAL laws and indeed the rules of most of the international arbitration institutions. There are three elements that the judiciary should be and must be trained to become involved in. The first is on the selection of the arbitral panel, the tribunal itself. There, of course, the courts, the judiciary will need to understand the way in which members of the tribunal and the tribunal itself are constituted. Is it legitimate? Is the individual on the tribunal the appropriate, in accordance with the law, person to be sitting there? Secondly, then, there are the challenges to the award itself. And yesterday, with Toby Landau, there began the debate a little bit about that, and I will go into that in a little bit more detail in a minute. And thirdly, and perhaps most importantly, there is the enforcement under the New York Convention. Unless the judiciary have a knowledge and a competence, dare I say, in those three areas, then arbitration as a process will fall down and it would fail on the international stage. So an institution must enhance and affect and train and learn with the judiciary in the areas in which it operates. Coming to other elements of the arbitration team, those who are starting out in that profession also need specific on-the-job, as it were, training, and that can be delivered through the tribunal secretaries process. That is a relatively new innovation, but has been a stepping stone for those who wish to enter into the profession and ultimately become arbitrators, and it is important that they too are trained properly. Then there are other people, other members of the team to be trained. The expert witness. How should they approach the preparation of their report? How should they give evidence? They need that training too. And we heard yesterday from Toby Landau again about the hired gun. We therefore need to actually train the party representatives as well into how they should instruct their experts and how they should develop and work with the expert before the evidence is actually given. And lastly, there is the mercantile and the commercial organization behind it, the people who are actually using the whole process and have decided to settle their disputes by arbitration. If any element within this process is not properly trained, then the process itself will fail. The institutions, therefore, in drawing this element together, have a considerable part to play in making sure that the arbitral process is efficient. Looking at that efficiency, the second element is then I am moving into the question of ethics. This has been something of a debate, but it is very important that the neutral behaves in a proper manner and conducts, the arbitrary tribunal then conducts the case in an appropriate way. We have a code of conduct in CIARB, and that sets out 9 elements that we expect an arbitrator and a member of the Chartered Institute to abide by. First of all, conduct unbecoming. Clearly, I think it is self-evident that an arbitrator should behave properly. Secondly, that they should behave with integrity and fairness. Again, self-evident. But then we get into some more details. Conflicts of interest. The arbitrator must declare any conflict, apparent or actual, that they have with the particular process. Second, we move on then to information. The information given to the parties must be consistent and it must be fair. The communications must be appropriate. And then the conduct of the process itself. The arbitrator must prepare. They must be on top of the paperwork. They must understand what the case is about. They must not be influenced by outside pressure. They must not delegate from their role. And here, the interaction with the arbitral secretary is of an interest. And they must not delay the award. They must declare their competence. It is no good accepting an appointment in a topic of which the arbitrator has absolutely no knowledge. There must be trust and confidence. And lastly, for perhaps the non-normal institutional arbitrations, the fees charged by the arbitrator must be reasonable and proportionate. Now, it's all very well having a code of conduct, but it must be enforced. And if I can tell you that we as an institute do enforce misbehavior on behalf of our members rigorously, to the extent that a past president some years ago, who had failed to render an award for 4.5 years after the case had been concluded, was expelled by us. That is how, excuse me, that is how seriously we take the question of ethics and the behavior of arbitrators. I turn now to that learned society. It's something of a nebulous definition, but what it really means is that the thought processes behind ADR techniques. Toby Landau, yesterday, he quoted from the London Principles of a Safe Seat. That is a good example of the thought process. We as an institute had a debate about what a safe seat would look like. And now, as you heard from Toby, those principles are being utilized by institutions and countries as they wish to develop arbitration as a dispute settlement technique. If one looks at the way investor-state arbitration and treaties are resolved, where they have disputes, there is a current debate in UNCITRAL, started by the Europeans, as to whether arbitration is the correct way in which investor-state disputes should be resolved. Well, we have taken a lead in that, and we have put together packages and debated publicly as to how we can evolve an evolution rather than resolution in going down when we have a practical solution to the way in which disputes can be settled. Don't tear it up and throw it away. That again is another example of how an arbitral institution can influence and develop the thought process behind ADR. Conferences. We develop the thought process through our conferences. Next year, we have a flagship conference, in fact, the flagship conference, to be held in Dubai, I beg your pardon, in Beirut, in June of next year, on post-conflict reconstruction and infrastructure development in the MENA region. There, we are involving all those parties that I outlined earlier in the arbitral process. We are asking judges to come along. We have obtained corporates in the construction and oil and gas fields to come to explain what those projects are likely to be. We've asked the financiers to say how those projects will be financed, including PPP. And of course, we have asked the arbitral institutions to join us to explain how any disputes that do arise, and there will be disputes, can be resolved. So you can see it's not just talking to lawyers, but we're actually looking to bring the whole team together and develop the way in which we can avoid, we can manage, and we can resolve disputes. Lastly, I look at the facilitation of ADR. Many of the panels over the last day and a half have been dealing with that topic, and I won't go into it in huge detail. We have just heard how third-party funding can have an effect within the arbitral process. We've heard just now about looking at the growth in multi-party arbitration can be dealt with. But I take issue with Toby Landau on one point. I believe that the rules and guidelines are there for a purpose. Yes, there may be a plethora of them. And yes, for international arbitrators who have been practicing for 20, 30, 40 years, there may be little need to continually refer to those documents. But for most of us, I would submit that actually we do need to have the place where we can go to see how we should deal with witnesses, to see how we should cross-examine, to look at the way in which documentation is prepared, and that's a huge issue for most of us. So all of those, I think, go together to facilitate ADR. The rules that the institutions have, the guidelines that are produced, are of value and should be referred to. So looking at the cost efficiencies, by training the whole team of individuals and entities that are involved within arbitration, we will get a better, more efficient, and the reputation of arbitration will grow. The knowledge base in the way in which we approach ADR will also grow by conferences such as this, held by an institution, and the team within it, the secretaries, the parties, and the tribunals, the appointed experts, will all benefit from that. I hope that you can see that the institutions have a major part to play. In fact, they are the core element. And on that, thank you very much.